Part B of the statutory summary suspension is important for law enforcement. Specifically, under the statutory summary suspension, implied consent. Any person who is dead, unconscious, or otherwise in a condition rendering the person incapable may not have deemed to withdraw their consent. In other words, there's an accident, the individual is a person who is unconscious, who is dead or otherwise unable, unconscious of refusing to, in fact, to give consent. So the officer may, in fact, go ahead and draw the blood under the circumstances and not have the defendant's refusal. The only important thing would be that the warning to motorists, which we will talk about, is read and the statute is complied with. 11501, the statutory summary suspension, is a very unusual area of law. As prosecutors, it is incumbent upon you to know the law, to in fact get all the case law and get it into a trial notebook that you know. From the defense standpoint, they must know the statute. They in fact must know what they're going to do and how they're going to proceed with it. Once the arrest is made and the law enforcement officer either has a consent for a breath test or has a refusal by the motorist, the law enforcement officer then shall serve immediate notice of that statutory summary suspension or revocation to the motorist. And that is, in fact, what triggers the event where the blood alcohol is either a refusal, the blood alcohol is over 0.08 or greater, or any amount of drugs, substances, compounds, Cannabis Control Act, or methamphetamine. The statute requires that the arresting officer shall give notice as provided in the section. And if in fact it's not immediate notice to the motorist, if in fact it's a 0.08 or greater on a breathalyzer result or refusal, the individual must be mailed a notice of that blood result or urine result in the United States mail. And it provides that it's in an envelope with postage prepaid and addressed to the person at their last known address. If the officer has their last known address, they've complied with the statute. Interestingly, there's new case law that indicates where the police officer in fact sent the notice to the last known address. The motorist said they didn't get it because they had moved. It is incumbent upon the motorist to in fact notify them under the Secretary of State's rules of their latest address. So the officer is only obligated to send it to the last known address with postage on it. It is not required to be mailed certified. Also then, once that is done by the police officer, it is incumbent upon the police officer then to file all the paperwork with the circuit court of the arrest, and then the suspension should begin on the 46th day after the date of the arrest, pursuant to the rules and the regulations of the Secretary of State.